everyone, and welcome to our webinar on the governance and legal requirements for managing community buildings. My name's Tracy Bird and I run the SCVO Information Service. And thanks to you all for joining us today. And just to note that this webinar is being recorded and it will be available later on the SCVO website. And also we will send out slides and any additional resources to you all afterwards by email. So anyone managing a community building will have faced many challenges over the last 2 years as the pandemic forced closure of facilities. Community groups were unable to meet. Income was severely affected. You've all proved your resilience, and hopefully with the safe reopening of facilities, we're now entering a more positive phase and can return to many of our previous activities. But that reopening doesn't come without its challenges for the trustees responsible for the management of these community facilities. So I'm delighted today that we have with us Robin Fallis and Gillian Campbell from MacRoberts. They're experts in all things governance and property. And MacRoberts are really active partners in the SCVO free legal advice service. And that offers SCVO members up to 2 hours of free legal advice on topics ranging from property and employment law to governance, charity law. And if this is something you'd like to know more about, then do check out our website. We're also joined by Christina Hines from Edinburgh Voluntary Organisations Council. And Christina does a very similar job to me in supporting charities and voluntary organisations. And she first suggested running this webinar. So Christina will also be able to tell you more about the common issues faced by organisations in Edinburgh with regard to community buildings. Now, just before I hand over to Robin, I'd just like to run a quick poll with you, just to get a sense of where you're all out at right now. So I just wanted to ask, is someone responsible for running community buildings? What's your biggest issue problem right now? Is it drafting agreements for hire? Is it all about the risk assessment that you have to do? Insurance? Is it COVID guidance for the safe use of the space? Or is it something else? And if it's something else, do put it in the chat and, we can get some interaction going there. So up to now, it seems like most people drafting agreements for hire. So that's good. Gillian's certainly going to cover that. But risk assessment, COVID guidance, that's quite high on the agenda as well. Great. Thank you for taking part in that. What I'm going to do now is I'm going to hand over to Robin. And before I do that, though, do post your questions in the chat as we go, because we've got loads of expertise here today. And we'll get to those at the end. So over to you now, Robin. Thanks.
Thank you, Tracy. I should have just shared my screen. I'm sure that Tracy will tell me if it doesn't in a while. And I'm sure she'll tell me if there's any issues with my sound as well. Thank you and hello to you all. I'm absolutely delighted that the poll did not put insurance as the topic that you all wanted to discuss, because that's not really hard to me. But I think Gillian will be able to very much cover the different forms of property agreements, and hopefully my bit will touch on risk assessment. So firstly, hello, I'm Robin Fallis. I'm a charity law partner at MacRoberts. As Tracy's mentioned, worked with the SCVO for I think 14 years now, with the Pro Bono Legal Service, and a member of the Law Society Charity Law Subcommittee, so much versed in that. My colleague Gillian comes at this from very much the property aspect. So between the two of us, I am going to talk very briefly, light touch on trustees' duties, because I assume a reasonable start point on that for those on the call. I'm then going to sort of delve into a little bit more about risk management in the property context, which I hope will be useful. I think at that point, Tracy may sort of see what sort of questions have come in from the floor before Gillian gets into talking about understanding different forms of property documents and the considerations there. And if all goes swimmingly, we usually find that the most useful part of these sessions is the discussion that's generated from what we've been talking about, because I appreciate in what we're talking about, there's various different levels of knowledge and experience across the room. So some may have very technical questions and some may have quite broad questions. So that's what we're aiming to cover today. And if I go on simply to looking at trustees' duties, I should say that I work a lot with Oscar with charities where things go wrong, and so I have a good insight into what they look to sort of pick apart there. I appreciate there may be people on the call that are community bodies that aren't charities. At the moment, I'm talking about the duties for charities, but in many ways, as we'll see in a few slides' time, those mirror across other forms. So if you're a community body that's not a charity, it's generally the same set of principles that come into play. The duties are to act in the best interests of the charity, act in accordance with its constitution, which I will not major on. And the third one is the really important one for property. Act with care and diligence that it's reasonable to expect of a person who's managing the affairs of another. And in the community building context, if you like, that building is an asset of the charity that you are managing on behalf of the community, or however it's defined. And so the legislation puts a duty to act with care and diligence there. With that in mind, I just want to sort of drill down a little bit more, and this is reflected in Oscar's guidance on what is expected under that duty, and it's to ensure that the charity meets legal requirements. Sorry, just quickly had to dive and turn my laptop battery on. It was telling me it was about to die, so close shave there. Acting with care and diligence, ensure the charity meets legal requirements. In the building context, we'll come on to health and safety and the specific sectoral legislative requirement there. In other areas relevant to community buildings, it can be housing regulation in some instances. And even recently with COVID, when we've had legal requirements from COVID, ensuring that those are met. One that comes into play a lot with buildings, ensure the charity has sufficient funds, particularly if it's rented or as a mortgage on a property. It's about ensuring that the income from the activity of the charity and leasing those out or renting those out means that it has sufficient funds for that. Protection of charitable assets, that really comes in being able to show that you as a body of trustees have done what you need to do, have acted with care and diligence to have the correct insurance in place, to have the correct policies, procedures in place, so that you are maintaining that building in its good form and not exposing it to risk of somebody coming in and suing you such that you have to sell the building to pay for it and such like. And Oscar say, look, what they're looking for across this is a reasonable business sense in the decisions being taken and appropriate advice being taken. And a large part of what we'll come to talk about in the sort of risk management is as an organization managing a property, being able to show that you've sort of gone through these processes, thought them through, and so that you can show back to Oscar or anybody else, and we'll come on to them, who wants to see them, that you've thought that through as a body of trustees. So I think I have survived on my laptop, which is good news. Worthy of brief mention, again, I said maybe not everyone on this call is a charity. For the charities, the Office of the Scottish Charity Regulator is potentially looking over your shoulder if things go wrong, if somebody gets injured in your building, if somebody gets COVID in your building and raises it, that they're not happy about it, if those sorts of things occur, if somebody says, hold on, that charity's allowing Donald Trump to use a little part of its building, what's going on there, Oscar, then that's where they can be involved. Other relevant bodies not to lose sight of, HMRC, and we'll touch briefly on that. I am not a tax expert and Gillian's not a tax expert, but we do have sort of sufficient knowledge of the issues. The tax elements are, if you like, an hour in themselves, but hopefully we'll be able to touch on any questions that come back from that. I mentioned important sectoral regulators relevant to this: governance, risk assurance, obviously the health and safety executive, and then quite frequently, and maybe it's relevant to some people on the call, you'll have core funders or organisations that have maybe in turn sold or leased you the building. It might be community right to buy, it may be an involvement with the council, who are sitting wanting to know that your organisation has all the correct processes and procedures in place and is doing things properly. And lastly, members of the public, staff, members of the organisation are often keen in ensuring the overall governance protocol. So I said I'd come to sort of a slide that pulled this together and also showed why it's relevant to charities and further. So focusing on the trustees to whom those duties apply, supported by management, executive, and potentially staff, depending on the size of your organisation. You get the charity law duties that we talked about there. And we get, if you're a company, you'll see a very close correlation with the principles which I mentioned. You know, instead of best interests, it's promote the success of the company, and you have a duty of reasonable care, which is a slightly lower duty than the charity duty, but still one where you want to demonstrate that you've gone through all the appropriate processes. And finally, there are a suite of risks that aren't, if you like, specific to charity law or company law or something else. They are under the common law, and these are the ones that, you know, risk of somebody suing you for being negligent or not having put in reasonable processes. I think quite often the one that's used is, you know, someone tripping over a broken pavement outside, but similarly someone tripping over a broken tile within your building leads to these sort of arguments around duty of care and liability there. And again, on this, we see the health and safety executive as sectoral areas where the risk management perspective comes in there. Very briefly, just to demonstrate a point, there are some of these areas can be dealt with very sort of quite concisely within a body through a timetable or a review check, and I think they should turn green as I press the button. They're relatively simple, if you like, to deal with from a charity governance perspective. And likewise, there are a suite of duties upon you that where you're documenting your decision taking and taking advice as appropriate, that largely carries out the, if you like, the bit that Oscar would check. It would want to see that you had documented why you took the decision. It would want to see that you had taken advice in an appropriate context. And again, those should turn blue just now, the best interests, acting in accordance with law. And that leaves, if you like, the difficult ones. And the difficult ones are the ones that charities tend to then need to really focus on in their risk matrices for running a property. So how are you squaring off and showing that you're meeting the levels of care that are appropriate? How are you showing that you've considered the risks, the duty of care to people using your building? So hopefully that puts a little bit of context around the duties and how they then mirror into what you are doing in the risk management sphere. So again, I think I've mentioned briefly as we've gone through, but examples of the risks are the ones that we see most frequently, including through the SCVO pro bono service where we get involved, is you know, financial risk. You may have somebody that's used your building and they don't pay for it, and you've got a cost and you were expecting this money coming in, and then you don't have that. Quite often that's accompanied by a lack of a proper document, and again in the survey at the front end, you've all indicated that that's quite an area of interest in making sure you know how to document things properly. Recently, in the last little while, over the last 3 years with COVID, even the most diligent of building operators have hit hurdles on the financial side where those that are the tenants in their building or using their building have simply folded because of the circumstances. And again, there's not much you can do about that, but as a board of trustees, you need to sort of be aware of that and documenting the risk and looking how you're going to address it. The next one that I've said there is financial, but that's more of a focus on being exposed to, for example, an uninsured risk, not having adequate insurance and suddenly being faced with a £50,000 bill or something where you've only got a reserve of 20,000. And again, we'll come on to sort of how we see people just dealing with this, managing this as they go through. And then you've got damage to the building, how it interfaces with those using the building, tenants of the property. And again, I mentioned you could have instances of somebody saying, hold on, I tripped up in your stairwell, the common stairwell of the building that was open to the public, and I hold your charity responsible and I want recompense for it. And lastly, reputational, and we'll touch on how you can sort of control or regulate this through the documents that you put in place. But an example of it, the simple example I gave earlier was, Donald Trump using your building, and somebody saying to Oscar, how can that be reconciled with the charitable purpose of promoting community involvement or whatever else? So those are the common risk areas. It's not a full narration of them all, but just to sort of pull them out. In this next couple of slides, I don't think it's new to anybody that I said it before, what Oscar's looking for is Oscar's looking to see that in order to meet the charities trustees' duties, the trustees have thought through these risks and taken appropriate action to demonstrate that they've acted with the appropriate care and diligence. And the risk matrix is the way to do this. And I know that people on the call will have them, and they'll probably be of varied levels. Some will be short, some will be long. But essentially, it sets out responsibilities, sets out ways in which you're mitigating risk, tools that you use to mitigate risk. And what it does is it serves to demonstrate that you've thought through that process such that wherever there's risks, you've mitigated those. And put another way, what it does is it says where there are those difficult areas of duties of care, negligence, care and diligence that's needed, you sort of map out how it is that you are doing your best, doing what's reasonable to meet those. And again, the problem areas there, the ones where you can sort of fall short on the duties, is if you fail to identify a risk or it's not followed through on. So moving from that, and this is a very rudimentary in this next slide, example of the sorts of things or the sorts of layout of the risk matrix that's helpful for this in the property context. And again, and just picking up on some of the things, this tends to be what you want to have. You want to have the area of risk identified on the left-hand side, the mitigating measure, so that the charity can show, well, hold on, I identified that risk, and then this is what I've done to address that. And it's quite helpful to have an example of how the charity then categorizes the residual risk there. So you'll see that we've got low for most of them, and again, reflective of, say, COVID for financial and loss of income. That might be something that the charities had as slightly higher over the last little while. And again, the last bit is the sort of next follow-up. So quite often it's, making sure that, okay, insurance is dealt with for now. We need to sort of program that in for when that's next going to happen, when that's next going to be looked at. It's probably worth me saying, I think you are getting a copy of these slides, and it's not my intention to go through line by line, word by word, everything in this. The purpose of it is for those of the organizations that don't have risk matrices, just to give an idea of what it's useful to have. I imagine that it's probably going to be, for the people on this call, reassuring that what they are doing, what they are covering is broadly correct, the approach that they're going at it. And last on this is absolutely not a full risk matrix. It's just a small example on the slide. There are, of course, very many things that are not on this slide that are relevant to property you'd be wanting to cover off as you go. Okay, last from me before we move over to Gillian and specific property inputs, and last on that sort of risk assurance, risk mitigation point, I think it's worth touching on health and safety, because it links into the duty of care. Are you doing things reasonably within your building? It links into much of what we've seen in a way with COVID and the specific COVID regulations. But on health and safety, you have obligations that are placed on both the organisation and the duty holders or the trustees as a body. And ultimately, boiling it down, it's obligations to take reasonable steps to prevent harm in the building. I'm not an ambulance chasing lawyer, but it is worth noting that health and safety is one of those areas where it's a sort of risk in terms of fines and indeed prosecution for the organisation, but also a risk for trustees. And I just say that because it's worth noting in the round. A charity trustee myself, been through the same thing, been through health and safety considerations, and I don't get overly concerned about it. I think it's more just worth being aware of that. Probably the fourth bullet is the most interesting one, the one to be aware of, because this is really the practical things that you require to do, and it's risk assessments, key to your sort of owning of the building and also the different uses of the building. And I think it's quite interesting. You've seen various things with COVID over the last little while where, the protocols have changed from going in one part of the building, coming out another part of the building, meaning that, a car park can't be used, meaning that, to make sure that the children coming out of a scout event or whatever are safe. So it's also updating risk assessments to what's happening on the ground, having things in place and then going, okay, well, we need to update that in light of COVID and keeping a look at it. And if you take that back to the slide before, you can see how that fits into keeping things under review, that fourth column of a risk matrix. Again, maintaining safety equipment, fire extinguishers and the rest. Very importantly, having a health and safety policy. And again, if you take that back to the earlier slide that was saying in certain circumstances, if you don't have the expertise or comfort, then getting that advice, whether it's from some of the organisations that I think Rhonda and Tracy will throw up information about or wherever else, important to do that. Clear posters and signage, first aid kits, and as relevant, training to those who are operating the building. That's a very sort of light touch on the whole of the risk assurance piece and how that ties into the trustee duties. And that really ends my contribution to the first part of this seminar. But before I pass on to Gillian, from whom you are going to get the specific property expertise, I'll pause and just see if Tracy's got any, hopefully not difficult questions from the chat. And if not, we'll move on.
Well, other than not inviting Donald Trump to any of our buildings, that was a good call. There was a question about recruitment of caretakers and staff, which, Robin, that's not your bag. I would say to people, try Good Moves, which is a recruitment website that SCVO run. And there was a question about COSH sheets, control of substances, hazardous to health, but that would be the health and safety executive, wouldn't it, Robin, for all of that? And somebody had made a comment, just a general comment about how organisations in Edinburgh could collectively market or have a booking system for various community facilities. I think that's a great idea. Maybe our digital team could look at that. I don't know, Christina, do you know of anything in Edinburgh that maybe people could advertise their buildings on?
I don't know of anything that's specifically set up for that. That is something that we get asked a lot about pretty regularly at EVOC when people are looking for facilities for a meeting or an event. So I think there is a need. I suppose the difficulty is pulling it all together and keeping it up to date. But yeah, that's certainly something that we could discuss further after this. Okay,
thank you. Well, thanks, Robin. I'm sure there'll be more questions come in as we go, but I'll hand over to Gillian now. Thanks. Are you there, Gillian? We can't hear you. We can see the slide. Rob and I are hoping that neither of us are going to have to do anything on property law. So I'm hoping Gillian's there. She's not on mute, so we'll just give her a couple of minutes to try and come in. And somebody else has just suggested, actually, while I'm waiting for Gillian, Glasgow Live have a hire a community space page. So maybe Edinburgh could look at that. Yeah, we've got Gillian here. Gillian was having a couple of technical difficulties before. I don't know what, Gillian, I don't know whether you want to, oh.
Can you hear me? Can you hear me now?
Yes, we
Is that
can hear you
better?
now. Thanks, Gillian.
Okay, sorry. There'll be a bit of rummaging then. I'm just going to use my headset. Hold on a sec and I'll just use that.
That's no problem. And I think Robin's going to just forward the slides on for you, Gillian.
Hello, sorry about that. Good. What I was saying, sorry, I'd also switched off my video because things were breaking up on my surface. So to avoid any interference, but at least if you can hear me and see the slides, that should help. So I work with Robin and the charities team, and me and my team answer the property questions that come in on the SCVO pro bono helpline. So what I thought I would do is initially have a look at a few points that arise for charities taking a lease of property, and then move on to looking at the granting of rights to use your property, whether you lease or own a building. So firstly, looking at some 5 top things to think about if you're taking a lease of a property. And these are common points that we encounter when asked some questions, and often slightly too late when we've actually got a lease. And it's best to think of these points at the beginning when you're discussing with someone taking a lease in your heads of terms, or when you're discussing the main points. Quite often you might think of the amount of rent and the property and how long you want to take the lease for, but there's a few factors to consider in all of that. And firstly, I've said the property. What does the property include? And that might sound like quite an obvious point because you know what you've been to see, whether it's a building or a room, but it's worth bearing in mind the extent of that property, as that will determine what your obligations are in respect of it. So on a building, are you liable for the exterior and the interior? So it's the whole property and the roof. Or for example, if you're taking an office or premises in the ground floor of a tenement building, quite often in leases, they'll impose an obligation on you to pay any sums due by the owner of the property. And in a tenement building, that might include common repair costs, which you're not anticipating. So have a think at the beginning where the property is and what is involved to try and exclude additional liabilities. Another point to consider is what rights might be required if you have a property that has, say, a shared yard or access, that you have rights to use that. Do you have rights to park vehicles? Are other people entitled to use it, which might create a problem? If it's let to you in its entirety, you will be responsible to repair it, so bear in mind the condition of it. If you're simply letting a room, do you have rights to use kitchen facilities, car parking, toilet facilities, etc.? So look at the whole. Then the next one is the duration. You can consider how long you might wish to use the property for, and quite often you want to secure that longer term. But think about break options. They're quite commonly accepted now, that you can terminate the lease at certain intervals. You'd want to avoid the landlord having a right to terminate the lease they're not expecting, as that can incur additional costs for you in moving premises and relocating. Try to avoid any conditions on the break. So if you're jotting down and agreeing terms, do try to limit it to giving notice only, as it's a whole other seminar topic on how break rights can be avoided if they've got too restrictive conditions. And one point to note on Scottish leases, which sometimes is not obvious, is that if you actually have a lease at the moment, current law is when the lease comes to an end on the expiry date, it will continue for another year automatically, unless either the landlord or the tenant serves a notice to terminate it at least 40 days before the expiry date. Now that can be a good thing sometimes, and it can be a bad thing. And the Scottish Law Commission is currently reviewing the law on that because it has caught out a number of people unexpectedly. So just a point to be aware of at the moment. Thirdly is alienation. To look at how you might use it. Might you want flexibility to assign it in the future or to sublet to another party in parts if you think you might want multiple users sharing your building, or simply the right to share occupation as well with other users. Flag that up at the start as well, as it's helpful to set that out so an owner knows potential users of the building to come. Then the final 2 points I wanted to mention just on taking a lease. Repair obligations. These can be the unseen costs to be incurred when Robin's talking about risk assessments and what your future liabilities might be. And that takes me to the first point on what the property is. The property determines what your liability might be to repair. What does an FRI lease mean? I see this frequently in heads of terms, and for people who don't frequently deal with properties and look at heads of terms, commercial leases, they don't appreciate what an FRI means. An FRI stands for full repairing and insuring, and for a tenant that means you're going to be fully responsible for repair of the building and to keep it in good and substantial condition, irrespective of if it's in that condition when it was let to you. So I recommend, if you're taking a lease of substantial premises, definitely involve a surveyor to have a look at the condition of the property and advise you on what liability you should accept, whether you can exclude liability for defects, and request a schedule of condition, which is a record of the current condition at the start of the lease. If you have a schedule of condition, you can limit your obligations to keeping the premises in the condition which you were given. So if there's a major problem with the roof, you're patch repairing it rather than renewing the whole thing, which you might be liable for under an FRI lease. And again, as I mentioned at the start, common parts, think about what your building is part of and what your liability might be on either common parts of the building, or if it's in a common shared area, to maintain external common parts and lighting, as that can lead to additional expense. If possible, you might want to cap any common costs at a certain annual amount. Lastly, insurance. Standard practice that the landlord insures the building, the owner of the building will insure, as he's at greatest risk if anything happens. So it's not usual to allow a tenant to insure just in case they don't do so. But it is standard practice that the tenant pays for the insurance. Sometimes in leases, the landlord can have what looks like a nice short form of lease, but unfortunately, it can mean that several of the protections we would expect for tenants are omitted. And that's quite common on insurance. So you might see you've got an obligation to pay the insurance, but actually the landlord doesn't have an obligation to insure. You want to make sure there is an appropriate obligation. There's also an obligation on what happens if damage is caused by an insured risk, that the landlord has to reinstate that you don't have to pay rent for the property or any part of it whilst it's unusable due to damage by an insured risk. And if it's not reinstated within a certain time, that you have the right to terminate the lease. It is standard practice in leases that the landlord is given, sorry, Robin, given some time to reinstate, and that's for their insurance. Usually for a landlord to insure against loss of rent, they have to be given the right to reinstate and then have a tenant come back in. So that standardly applies in most leases. And then turning to granting rights to use your property and what kind of documents and agreements you might have. So I've summarized here the 4 main ones that we commonly see. Firstly, a lease, then a license, then you can also have room hire agreements and service agreements. But as I've said there, please always have something in writing. It's important for you to record who's using your building and in what terms. Even something very short is better than nothing at all. But properly drafted agreements are helpful. And I'm just going to turn and look at what the differences are between the types of agreements and then onto when you might use one. So if we could turn to looking at what's a lease and what is a license, and they can be used overlapping. It doesn't necessarily mean that a lease is a very long document and a license is a very short one. They have a different basis in law which applies to the rights that the occupier has. So firstly, looking what is a lease? A lease is an interest in land, so it's called a real right, and that means it's binding against successors. So if you grant a lease to a tenant and the owner sells the building, the new owner is bound by that lease. They can't remove the tenant. It stays in place. The tenant has the right and a lease to assign it, and then that's normally governed by some restrictions in the lease on who you can assign it to. Termination for breach, what we call in Scotland irritancy, is regulated by statute. So there's certain provisions a landlord must follow to terminate it. And during the COVID restrictions and lockdowns, UK-wide, there's been, although applied slightly differently, restrictions on landlords being able to terminate leases where the tenants have been unable to trade due to lockdown. So that's something to be borne in mind either as a landlord or a tenant. And leases are subject to LBTT. Charities can claim relief from LBTT, but the return is still due on a lease, and there is a penalty for not submitting a return on time. As opposite to that, what's a license? Well, a license is a personal contract. It's simply a contract in law. It's not binding on successors. So if the owner of the building sells, your license won't bind the owner. It's a personal right, and it's granted to the specific person, and you don't automatically have a right to assign it. As a contract, it's not protected by statute, which applies to leases, and it's not subject to LBTT. Sorry, I see there is a question on what is LBTT. That's Lands and Buildings Transaction Tax, which is what we now call stamp duty. If you know what stamp duty is, which you pay if you buy a house, it's now called LBTT, and it's payable on leases as well, calculated by reference to the length of the lease and the rent that you pay. Sometimes people use licenses to avoid the protections that are used, are benefiting leases, but it's possible that a license is actually a lease, whether you call it a license or not. If there's 4 fundamental bases of what creates a lease, and that is when you grant exclusive possession. So, and it doesn't matter if that's just of a room or a building, but if only one occupier is entitled to use that space 7 days a week, then that's what we call exclusive possession. That occupier pays a fee or a rent for the use of the room or accommodation. It's of fixed premises, so you say room 7 and you've leased room 7, not that you're saying you can have room 7 or another room in the building, and it's for a fixed period. So, and that can be short, so it could be a week, a month, but it's not an hourly use. So if you've called something a license, it can in law be treated as a lease, and the way to avoid that is usually what people try to do is not grant exclusive possession. So they say we can share that building with you, or we have a desk in that room, or we share your boardroom on so many days a week or a month. Or where it's something like a room, you say we'll give you the right to use a room in our building. The initial room we designate as room 7, but we have the ability to change that to room 9 at any time with giving you a little bit of notice. And that would be a license and not a lease. So you might want that if you want flexibility and you think you don't want to grant someone sort of long-term use of a room that you may want in the future, but you do want to say to them, yes, we're happy for you to use some space in our building. It's just we're not going to guarantee you it's this specific space for the length of your agreement. So when you might want to use a lease or a license, the duration and length of the term that the tenant might want. Recently, we were acting on use of a community building, and we had different forms of agreement for each different occupier. So there was another charity that wanted to actually take up space on a assured basis that they knew they were going to have that accommodation for a certain number of years. And so that really lent itself to being using a lease to appropriately govern their rights and obligations in that time. If it's for a shorter term, then you could use a license or a very short form of lease. Given the premises, as I mentioned before, if it's exclusive occupier and only them using the premises, that tends to be a lease. But if it's shared space, then a license would be appropriate. The occupier itself, if they wish to carry out any alterations and invest in the property, they may want to assure themselves that that cost could be recovered and not written off by being able to assign the agreement to someone else if they find the premises don't suit them any longer. So that might be a reason they would want a lease. And on a license, you might wish to control that use of part of your building is only by this specific person and group. So you want it to be a personal agreement and not agree a lease. And then moving on to the more short-term agreements, room hire agreements or service agreements. Room hire agreements pretty much say, as their name, that it's for a short-term hire of a room in your building. That can be simply per hour, so many days a week or one day a week, and they pay an hourly rate for that. You can determine, obviously, yourself with your occupiers the terms of the agreement, but generally, because it's such a short-term occupation, the occupiers has very limited obligations, and usually we'd find that would be restricted to not causing damage, leaving the room clean and tidy when they finish their use, and following any regulations that you might have. Service agreements are similar, but they can be, I've said there, for use of a desk in a room, you can allow people just to share your accommodation. But a service agreement is more commonly used where you might be providing extra services like photocopying, IT reception facilities. You can charge per daily use, and you can have an all-inclusive fee, which includes all the services, or you can charge an extra amount for some of the supply of services, depending on what they are and how often you think the person might use them. Commonly, you can have extra agreements for use of boardrooms as well that can be included in either of these types of arrangements. And then lastly, just to look at some factors to think about. No matter what type of agreement you have, you should always be clear on responsibilities, who's responsible for what, either in respect of the premises they use or the common parts. Usually in the short forms and hire agreements, the owner, you would be continuing with the majority of all obligations in respect of the building, and your short-term occupiers will have limited obligations just during their use. On licenses and leases, I've said there who maintains and who repairs, and who maintains and who repairs what. If you're the owner and you're granting exclusive use of parts of a building, you would want to make sure the tenant accepts responsibility for their area and to maintain it in the condition that they were given it. And that's also links into my comment at the beginning, to have a look at what condition it's in and what you expect a tenant to do. Insurance, if you're the owner, you should be insuring the building's insurance and advising them of the occupiers and who's using it. And that's public liability insurance as well, to make sure on your public liability insurance, does that cover all your users, or are you expecting your users to have their own public liability insurance if anyone was to have an accident during the time that they're using a room or their space. Statutory compliance, fire regulations and health and safety, as Robin's mentioned. As the owner of the building, it is primarily your responsibility unless you pass that responsibility onto your tenant or licensee. It's common in leases that the tenant is responsible for statutory compliance in respect of their own premises, and on licenses it can be as well, depending on the duration. Quite often it is affected by how long someone is going to use the space for. The longer they use it for, the more obligations they should have. And I've suggested always include an obligation on them to comply with regulations, reasonable regulations that you might make for use of the space. That allows you to adapt to have regulations that might reflect, for example, now COVID, if you want to put in specific requirements on all users and what you wish them to do, and face mask wearing and use of hand sanitizers, etc. You can cover that in your regulations, and then you can update them as appropriate. And so long as everyone knows what they are and circulate them, then you can ensure everyone complies with your requirements. And lastly, ability to terminate. You should always include that you can terminate the agreement if the occupier, tenant, licensee breaches their agreement, and you may want to terminate it on certain conditions, or if you want to retain flexibility, then you might want to have short-term agreements, or the ability to say that either party can terminate on a week or a month's notice, depending on what the person wants from the premises, and whether they're investing any money on carrying out alterations would affect whether a tenant or occupier is amenable to landlord's rights to terminate early. And I think that was all I had on the legal documents. And just lastly, turning to Robin for a brief comment on tax.
Thanks, Gillian. You can get a cup of water whilst Tracy sees how difficult the questions are for you. Yeah, as I said before, our tax expert is not on the call today, and it's a session in itself, but the sort of high level things are, don't forget about it in the context of your community building, the flows of money, the monies that the charity receives from the use of the building. Again, not a great surprise, need to be applied for charitable purposes. Again, you can think about any VAT considerations. I'm sure those of you that are up and running do so, and do so with your accountants or financial advisors. On the last one in particular, that's one that's sometimes sort of missed or not thought through, where you have rates relief as a charity managing the building, and then you're looking at commercial organisations that do not have special status, do not attract rates relief coming in to use different parts of the building. The important point there is to think about what that does to rates relief and to recognise that and you know, as necessary, speak with the council, get advice on it so that you know where you stand and don't get a surprise of suddenly finding that you hadn't factored in for rates suddenly becoming applicable. Again, I'll put a small caveat on it that I am not our tax expert and it's a complex area and one that recently has got interesting in light of certain developments that Oscar's been looking at. And that is us. So hopefully I've given Gillian time to have a little drink of water. Tracy, I'd like to have a look at any questions. And so we go to questions.
Yeah, great. Thank you, Robin and Gillian. That was great. The questions have been coming in thick and fast. I would just say, Robin, we do have tax experts within our pro bono service at SCVO. So members can access tax advice through that. Gillian, I don't know if you're ready for questions, but one Ms. Anne had asked that I was going to ask myself. If you're renting out individual rooms, does each group need public liability insurance on their own? Or would you put that you would take care of it for everybody?
You can do either. It's probably safest for the owner manager of the building to have public liability insurance that covers everyone if their insurer will agree to that, because then you're not relying on the individual users having their own insurance. So you've got that comfort that if something was to happen on your premises, you have it insured, and then you would factor in that cost into what you're charging people to use the rooms. So that would be what I would suggest.
Yeah. Okay. And there was some discussion around room hire agreements, and is it common to include setup and takedown time in the price? There's a few people have commented that they do that, you know, just to allow for cleaning with COVID. What would you say on that, Gillian?
Yes, you can vary your price, obviously, to cover whatever you would wish, and if people can still make money from their use of the premises on paying that. So yes, if that's certainly at the moment with extra cleaning required, then I would factor that into the room hire cost.
Okay. David Henderson's asking, is there any off-the-shelf occupancy agreements that can be used, and at what point is professional legal input required? And I'm aware I'm asking you as a lawyer, but what do you say on that, Gillian?
When I was helping on some, the client we had a few examples that Edinburgh City Council were using or suggested they might use for community groups. What we did on that was one user wanted a long lease, and for that there's a legal group called PSG who have some sort of standard form leases, and we adapted that. That was actually, although quite a long document, it was the quickest way to agree it, because that tenant had a lawyer and we knew they'd be familiar with that form of lease, so it was quite easy to agree rather than some short forms which, as I said, often omit the main things that a tenant might want. Bespoke sort of room hire agreements, I'm not aware of sort of standard templates of those. I have seen different ones that different people use. It might be something you'd want to look at having for your members if it's a common requirement, or as I say, the local authorities might have some that they are willing to share, especially if it's a community group maybe taking over a building that was previously run by the council. They would have forms that they used.
Okay. I'm going to bring Christina in there. Christina, are you aware of anything in Edinburgh? You know, it's sort of like a template that groups could use.
Just as Gillian has said, I think there are some forms that the council has used in the past. I'm not sure how kind of current they are and up to date. I know that there are room hire forms that schools will sometimes use for school lets. But yeah, that's something we can investigate what's out there from Edinburgh Council anyway.
Okay. Is there anything else that you wanted to bring up, Christina? Any sort of like frequently asked questions you're getting from groups in Edinburgh?
I suppose one of the issues that groups have raised with us is where, and this is usually with community centres, where it's a building that's owned by the council and obviously run by a separate charity and the management committee for the community centre. And there have been cases where they've been told by council officers that they need to have a certain level of agreement with groups using the building that might not actually be appropriate or might not be the right sort of type of agreement. So I guess we'd be interested to know what your advice is in that case. Is that something that should maybe be covered as standard in the lease agreement between the council and the community centres, or do you have other suggestions for dealing with that?
Sorry, I'm not quite sure I picked up the point there. Could you repeat it? Sorry.
Sure. So where there's a separate charity that's running a community centre that's owned by the council, and they are told by the council that they need to have, let's say the council says you need to have a lease with this group that's using your community centre, and they don't feel that actually that's the appropriate sort of agreement that should be used in that case. Would it usually be something that should be covered in the lease agreement between the council and the charity that's running the community centre to say when other groups are using the centre, these are the types of agreements you should have in place? Or
yeah, ideally that is what you would have, but it's not always the case. So if the council did want to regulate it, they might have their own templates, and they would say, you know, sharing occupation and sharing use this form. But if it doesn't say that in the agreement, then the community group would be entitled to use whatever agreement they think is appropriate, provided their lease allows them to share occupation with other users.
Okay, thank you. There's a couple of quite specific questions on health and safety, which I would refer to the Health and Safety Executive website. And I know GCVS, TSI in Glasgow, they have a health and safety experts there, so they might be worth contacting on that one. Also questions around insurance. I would refer you to your own insurers or Keegan and Pennykidd. There's details of that on our website. They run a special insurance policy for the voluntary sector, so they're worth getting in touch with about that. And there was also a question about music licensing, which I think is beyond the remit of this webinar, but we have information on that on our website. And I think Rhonda, who's been very helpful and been putting lots of links in the chat as we go, I would like to thank her, and Joanne, who's beavering away in the background. We're running out of time. I think that's been great. It's been really informative, a lot of information. So we will send out the recording and all the links to you in an email. I'd like to thank you all for attending today, and Robin, Gillian and Christina for their input. I hope you found this useful. SCVO have a COVID information hub on our website, and that's got some guidance on opening premises safely, so you might want to check that out. And also your own local TSI should be able to help you with any questions you may have. As I said earlier, if you'd like to access free legal advice and you're an SCVO member, do get in touch. Or if that's something you're interested in and you're not a member, have a look at our website. We've got lots more lunchtime webinars planned in the next few months, and we've got one at the end of March on trustee roles and responsibilities, and another one on charity trading. And you can book those up via the events section of our website. And they're all part of our trustee network, which I would encourage you to join if you haven't already. And finally, don't forget, we're making big plans this year for the gathering, which is going to take place on the 15th and 16th of June. And we'll be hosting the Scottish Charity Awards then as well. So if you'd like to nominate an individual, for example, Trustee of the Year, or any organisation in any of our categories, then you can find out more information on our website. But do hurry, because the deadline is the 18th of March. So it's 2 o'clock, and that just remains for me to say thank you everybody for attending, and thanks to all our panelists, and I hope you found that useful. Thank you. Bye-bye.
Thank you. Bye.
Thanks, Tracy.
Thank you. Bye.
Bye.
Thank
Bye.
you.
Cheers.
Thank you.